and you're welling on them, because this wasn't I hit him twice and he moved, because he ended up with marks on his thigh and on his back. And when you did that, you didn't even stop. You continued.
This case starts with a disturbing question. Where is the line between discipline and abuse? A father stands in court after admitting to injuring his own 9-year-old child, leaving visible marks across his body. Now he's asking the judge for a second chance, deferred adjudication, meaning no conviction if he complies. But here's the twist. He claims it was a mistake. The judge already sees it as something very different. And what happens when the evidence finally comes out changes everything.
To a child, which is a third-degree felony, according to the plea bargain agreement, punishment is to be assessed at a cap of 5 years. There's a $1,500 fine. The state is remaining silent on your application, and there's to be no unsupervised contact with Valentin Kesey. And you've applied for deferred adjudication. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
I'm sorry, I can't. All right.
Yes, Judge.
Any objections to the PSI report, state?
No objections from the state.
Defense, you have objections?
No objection, Your Honor.
I cannot hear you.
No objection, Your Honor. I'm sorry. That's the delay.
All right. Thank you. All right. So the state is silent on the application. Defense, do you have any witnesses?
Your Honor, Mr. Kesey will be my witness.
All right. Could you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. You're going to have to lower your mask because no one can hear.
Yes.
All right. All right. Could you state your name for the record? Jeffrey. All right. Thanks. I didn't hear the last part. Your voice went down. All right. Defense?
And Mr. Kesey, you understand why you're here today. Is that correct?
Yes, sir.
Okay. And you remember being interviewed and doing a PSI. Is that correct?
Yes, sir.
And during that PSI, you expressed a sorrow and some, you explained to the PSI interviewer the lessons you've learned from this experience. Is that correct?
Yes, very much so.
Okay. And briefly for the court, can you explain to the judge kind of what you've gathered from this experience?
I've gathered a lot down. The classes I took through CPS, I learned how to better deal with challenging situations and viewpoints on how to instruct my kids better. Also, being the first one in my family ever arrested, this has had opened my eyes to the system. Yeah, very much.
That right there, that's the shift. Legally, this is critical. The defendant calls it a mistake, but the judge reframes it as a choice. And that distinction matters. Because in court, a mistake suggests loss of control. But a choice? That implies intent and responsibility. Back-end index pointing right, let me ask you. If you were the judge, would you see this as a mistake or a conscious decision?
Sorry and apologize. I wish this never happened. It's the worst demon I've ever had. That should work good.
Okay, you're going to have to speak up because I know your attorney can't hear you.
Okay. This is the worst demon I could have on my back, which is the shoulda, woulda, coulda demon. And there's a lot of things I wish I could redo and do over. But I made the mistake. I'm being man enough to deal with this.
No, it's not a mistake. It's a choice.
It was a choice. Yes, you're right. It was a choice. It was a poor choice. A very, very poor choice for my son and my family. I put everything that I worked so hard for at risk, staying out of trouble for 44 years at risk. It was something that could have been handled way better, way different.
And Mr. Kesey, through your counseling with CPS and going through your safety plan, did you understand effective ways to instill proper discipline with your son?
Oh, very much so. I have a newfound aspect on how to form discipline for my son and my daughter, unlike how I was raised and how I was taught, which seems to be working a lot better. Getting better results out of him and myself.
And to your knowledge, CPS has cleared you of all, you're done with CPS's case has been dismissed from a CPS perspective?
Yes, everything I know of has been dismissed. I have the 2 certificates here of the classes I have completed. We also got my son, now that COVID somewhat died down, got him evaluated as well. And I have a better understanding of what is going on and better saying what's going on with me.
And it is your intent at some point to be able to have totally unsupervised visitation with your son. Is that correct? And establish that relationship better?
Yes. I want to rebuild and get back some of the time we lost at that separation and move forward and get closer as individuals and as a family.
And this is your first experience with the criminal court system, is that correct?
Yes, sir. First one in my family.
Okay. And it is your intention to, if you were granted community supervision or deferred adjudication, to follow that to the T, is that correct?
Oh, to the utmost of my abilities.
Okay. Your Honor, we have nothing further.
All right, any questions?
No, Your Honor.
I have questions.
Yes.
All right, so I always read the stipulations again, but I remember this case when I received it. So how old was your child?
9 years old.
And according to the stipulations that I've read, he was hit because he didn't make his bed.
No, God.
Okay, why did you hit him?
He was spanked. Okay, so let me go through this if I have time.
Oh, we have time.
Okay. My youngest daughter was sick. I believe she had COVID. And we had our nanny watch our other 2 children while we took my youngest daughter to get tested for COVID. Before leaving, I asked my son to mind Miss Berger, our nanny, while I'm gone, because he was on it all week. And he said yes. We left. Of course, it took forever to get the COVID test and get the results. While we were waiting, I got a video clip of my son hanging over the banister of the stairs, which is about a 10-foot drop onto the stairs. I told Eric I was handle it when I get home. We got home. I talked to my son. I reminded him of his promise. I also talked to him about why he was getting spanked, because he was already grounded from TV, grounded from playing with the dogs. I thought I tried everything at that time. So we talked, and I told him he was going to be spanking. We agreed on how many spankings he would get. Like normal, because I was still nursing a broken leg from falling in the snow here in February. Still had a brace off of that. The picture out, bending him over my knees and spanking with a belt on my hand. I had him stand up.
Up until this point, everything has been based on statements and explanations. But photos? That's objective proof. And in cases involving injury, they carry massive weight. What's even more concerning, the defendant admits he's never even seen these photos before.
In front of our bed and commenced to spank him. And unfortunately, he moved. I guess from what he has told me, the lower back
I mean, not what CPS tells you. Did you see the photos?
No, I haven't seen any photos.
Oh, State, do you have the photos?
Yes, Judge.
I'm going to show you the photos so you can see them. I find it odd that CPS would have you go through their program and not show you photos. Because then, if you don't see photos, then, you know, what do you know? What have you learned?
I'm not saying this.
Well, I've been reading these stipulations, and it appears that this is not the first time that you have spanked your son. And according to the stipulations, it says that your son is afraid of you. So I want you to see these photos.
Sorry, Judge. My computer knows
So-
it's a Monday.
It is Monday, but you know what? Everybody has some patience in their pocket.
Your Honor, would you want the video? So did CPS give you the video?
No, we're going to show the bruises. So here's, let me tell you where I'm coming from. This is a child. Children do tend to push boundaries, but I found in my short time on the planet, even though more of my life is behind me than in front of me, I found on my short time on the planet that children like boundaries, even though they try to push them. So whether your child was hanging from a chandelier, whether your 9-year-old was out at the club at 2 a.m., there's no excuse for this. Although I do tell people now, if your child is, Caleb from Children of the Corn, Damien, Rosemary's Baby, then we may be able to talk about this. But even then, this is not the right course to take. You understand?
Well,
I mean, not apologetic to me. You need to be apologetic to your son, because let me just tell you, when stuff like this happens, guess what? The bond has been broken. I don't know that.
Counselor?
I only know that in the report after this happened, your wife gives a statement saying you're a great father.
You didn't get any of the email?
Oh, I have the stips that are in here, but the fact that you've never seen these photographs before tells me that CPS may not have given you a well-rounded view of what's going on. Because I'm a firm believer, if you cause injury to someone, that's a physical injury, you should see it.
Sorry, Judge.
Oh, that's
It's
okay.
just technology. They're coming through. It's just taking
But
it.
see, that is why we should have printouts of photos. I remember back in the day, and Brent, I know you don't know about this. You had the camera with the flash you had to put on the top, and then you would have to take it in and have someone develop it. You know about that? Okay. Have you heard of Polaroids?
Yes.
We thought we were very fancy, once you got the Polaroid, and now you don't even need that.
Well, we would love to print them out, Judge, but you know how the budget goes.
Yes. And Mr. Lewis, were you able to view the photos with your client?
Judge, I did have received the photocopies. I have not reviewed all of the photocopies with my client.
Okay.
He has seen all the other reports, but not the photos.
Would you just like me to show him on the laptop, Judge?
Yes. And see, the problem where you're saying you didn't know you hit him on the leg, doesn't matter whether you didn't know you hit him on the leg or not. You left bruises on a child. Need to make sure your phones are off. So, Mr. Kesey, your son is afraid of you. And from those photos, he has good reason to be. So here's my question for you. Where was his mother when you were disciplining him?
She was upstairs to
And see, I find that to be a problem because I don't know if I can trust her to protect her children because she says you are a good father. And a good father does not do this. Parents should not be disciplining children if you believe in corporal punishment. And that's choices that people make. You should not be engaging in corporal punishment when you're angry. And obviously, you shouldn't be engaging in corporal punishment at all.
yes,
And I always tell parents this because I've done child protective services cases before. I always tell them, basically when you hit a child, you know what you're saying? Right makes right. And I'm in charge and you're not. So you have a child who's not your height, not your weight, and you're welling on them because this wasn't I hit him twice and he moved because he ended up with marks on his thigh and on his back. And when you did that, you didn't even stop. You continued. So don't give me this thing that you hit him once and he moved because the marks are more than hitting him once.
No, I
And
didn't say
answer me this. I'm sure he was crying when you were doing this, was he not? And what were you thinking when he's crying and you continue to hit him? Here's the thing. People make promises all the time. People will take the witness stand and swear to tell the truth and take an oath and then not tell the truth sometimes. So I've been involved with CPS cases where people say we're never going to do this again and they get their children back. And then guess what? 3 months later, we're back for the same thing.
You would never see me again.
So
The counselor here that was in the room that I made a promise to, and he's still going to those counselors. All my children, going to counseling, and I tend to go to counseling after this.
Who's your child's counselor?
Judge, that's Lori Berkman. She's present.
All right. Then I want to hear from her. So any more questions for Mr. Kesey, State?
No,
Any
Your Honor.
questions? Defense, any more questions for Mr. Kesey?
Not for Mr. Kesey, Judge.
All right. I want to hear from the child's counselor.
Thank you.
No, you're not dismissed.
At its core, this case was never just about punishment. It was about accountability, control, and the consequences of crossing a line as a parent. The defendant wanted leniency, but the judge made one thing clear. Harm to a child carries weight far beyond excuses. And with testimony from the child's counselor still ahead, the final outcome hangs in the balance. One question remains. Can trust ever truly be rebuilt after fear takes its place? Back end index pointing right, if this courtroom moment shocked you, hit like, share your opinion in the comments, and subscribe for more real courtroom breakdowns.